Good morning, everyone. We are here for our California call, and we have a few of our FFLGuard team along with our friends out in California. So we're going to start off with Mike. We're going to let you kind of give us a heads up on what you went over in the first call and then go from there. Mike, you got it.
Yes, I think we only got like four FFLs besides everybody else on here. So I think a couple of you, because I think Chris made a comment about Mr. Turner being studly looking in his photograph, I believe. And so, which was kind of funny. But now we'll get started right away. There's a lot going on right now. And we wanted to just go over some things with everybody. And this might be a repeat if you're on this morning, the first call. But I'll go over a couple of things. First is inventory. We're finding when we're going for some of our hearings, a lot of our hearings, a lot of people are not doing the inventory as much as they should be. And Hank will comment on this also coming up because he had some good comments on this too. But FFLGuard requires at least 4 times a year for inventory. Some of you are not doing inventories nowhere near that amount. You might be doing 1, if that. If not, you're finding some haven't done any. That's a requirement. Please do your inventories. Also, make sure you're up to date on any FFLGuard training classes. These are going to be updated, as Chris said last call, sometime this summer. Also attend any seminars you can attend via ATF. They're doing a lot of seminars currently with this fiscal year for them and calendar year. So make sure you attend some of those. A couple of things that ATF posted online I thought it's interesting is for the calendar year of 2022, 88 FFLs have been revoked. But the number that really stood out to me was the number of 93. These are FFLs that ceased operating after ATF conducted their inspection. And that was for a period of 1.5 years, meaning July of 21 through the entire year of 2022. And what that tells me with those FFLs that are ceasing operating after ATF did their inspection is could be a few things. One is that maybe their violations were so severe that they just said, I'm giving up. But it also means that ATF may have kind of pushed them in that direction too, because they had violations. And we've heard this from some of our people we've represented is ATF just told me just to surrender. It's not worth going to a hearing. Now, unfortunately, if some people are surrendering because of that statement, because ATF's saying that, that's unfortunate. And everybody has their due process to go to try to keep their license. So, but just keep that in mind too. If anyone to make that point is if ATF does say, hey, just surrender, you don't need to keep your license, your violations are too severe, say no, I'm gonna think about it and I'll talk to our, my attorney or anybody, and we'll get back to you on that. So don't just say surrender your license and be done with it. You've got a right to maintain that license and a defense to argue on your behalf. So keep that in mind. But that's kind of an alarming number. It's pretty high for people just surrendering without even going to a hearing right away. One thing, another thing I wanted to go over with everyone is NFA trust. We've had a couple issues with that recently. Not a couple, but multiple questions regarding the NFA trust. And if you remember, that whole thing with trust changed back, I think it was 2016 with ATF ruling 41F. So the main thing we're finding out is if we have somebody, an NFA trust who files, I'm going to stay with the Form 4 because that's where all the questions are coming through. Some people are sending in their NFA trust to purchase an NFA weapon. They send in the responsible person questionnaire because everybody in that trust who is a responsible person has to send that in too. And that determines who can pick up the firearm on behalf of that trust. Where the issues come into play is we're getting some questions on, hey, I've had every person that trusts or the one person that trusts has been deployed. They can't pick their NFA weapon up, or someone's been added to the trust and they want to pick it up, but the firearm's already been processed by ATF and sent back. So what they have to do, if say that person is not on the trust, they have to update that trust legally, and then they have to undergo a background check via the form 4473 before that person whose name was not submitted to ATF via that form 4 responsible person questionnaire. Once that person comes to pick the gun up, they're added to it. They have to see the documentation that they've been added. I'd keep that with your form, with your paperwork, but they also have to undergo a background check. That's just a short story for that. We've been getting a lot of questions on that lately. Other thing too is, I guess this might be old hat for some people, but Avis and I took part in a UPS kind of a seminar, very short one, maybe like not even 20 minutes long, but they just went over that all FFLs through UPS now need to have I'm sure a lot of you noticed already, a shipping agreement with UPS. They have to have a dedicated account number with UPS, and that's specifically for the firearm shipments. It's a way that they're able to get easier alerts to customers if there's any lost or stolen firearms, and it has greater security via shipping this way too, and that satisfies UPS's legal requirement as a carrier of firearms, which was an interesting statement that they made. So they also want, there's also, and you, again, I'm probably not saying anything that you don't know already, but there's, they don't want any labeling or outer box markings notifying or identifying the contents of the firearms package. And they want the shipping label to be abbreviated. For example, if it's Arnold Rifles Inc., they just want it to say ARI. So there's no identification of rifles on there, or that it's a firearms, possibly licensee even. So just want to make everybody aware of those requirements if you didn't know, but I'm sure everybody's doing that already because it's probably been out for a while. So it's not any news to you. So just wanted to make everyone aware of that going forward too. If I missed anything on those UPS information, let me know, but I think everybody's pretty much up to date on that. It sounds like from our last call anyway, and just so everyone's up to date. I think that's pretty much all I wanted to go over. I think I hit real quickly on stuff I elaborated more on, but I think Hank had something more he wanted to add too. Might be good to go to him about the inventory before we go anybody else.
Yeah, thanks, Mike. Yeah, absolutely. You know, if you were on the national call, I didn't mention California in specific. California is the one outlier nationally that's actually up about 30% on average over last year. So congratulations to you guys to doing better this year than the rest of the country. But from that perspective, doing firearms audits, FFLGuard has their standard, you know, at least 4 a year. But from a business perspective, I'm a big advocate of looking at it from two ways. One, a lot of stores hesitate to do an audit because they see it as this huge task that, you know, do I shut the store down because I want to stabilize my inventory, whatever. You know, break it up into you know, sort of manageable chunks, and even break it down. I've worked with some clients in the past who just do portions of their inventory each week, just little bits of it until you eventually cycle all the way through it and lay hands on everything. But the rule I use is to say, how often am I turning my firearms inventory over? So just to give a simple example, if you're carrying on average $100,000 worth of firearms in stock and you're selling $600,000 worth of firearms a year, you divide the 600 by the 100 and you get 6. That means you're doing 6 inventory turns on your firearms per year. And that's a pretty typical number for your average store. That dictates to me that you should be doing at least 6 audits a year. So it's every 60 days you should be auditing your firearms inventory, because that's, in other words, that's how quick I'm moving through my inventory, and I need to keep up on where any mistakes might be had before I start cycling through the next batch of inventory. And it's just a good practice because, you know, I've worked with folks, and even when I had my store, you get much past 30 days where there's some issue in your paperwork or whatever, the chances of your staff remembering what that oopsie might be, or where, oh yeah, we put this firearm in some hold area or whatever along those lines, you get much past 30 days and you just forget as to where the corrective measure is to get your book straight and to get things figured out before it gets too far down the line. Or based on the national call even too, yeah, say you find a missing firearm for whatever reason it's missing, it's better to report one than it is to wait a year and report 7 all in one fell swoop. You know, again, keep it in little smaller bites that show that you're staying on top of your inventory. But again, my metric is however many times you're turning your inventory, that's how many times you should be managing your audits on your own gun inventory. So FFLGuard says a minimum of 4. My guess is for most stores it's a minimum of 6, and do it in smaller bites. You know, do a little bit each week. Keep working your way through it from that perspective. To jump on some other pieces I talked about, again, California, thumbs up. You guys are doing really great on sales right now. But make sure from that perspective, and I'm going to say it from a flip of the coin perspective, from a payroll, making sure you got enough staff on hand. I know hiring people is difficult, but in a growing market like you guys are in right now, being understaffed can mean lost sales, and lost sales means you're giving a reason for your staff to go do business with somebody else. And if they happen to have a better customer service experience at that other facility, you may lose that customer long term. So do a quick assessment. You know, look at your total payroll expense, divide it by the total volume of business you're doing for the same period of time. And if you're down into that 14 to 12, or even, you know, below 12% payroll as an expense of revenues, that tells me that you're probably losing out on some sales, and you could do with hiring 1 or 2 more people to close some of those extra sales that you don't know you're losing. The customers in the store, they may have some product in their hand, and because they can't get waited on quick enough, they put it back on the counter and leave, or they don't ask a salesperson because they've been busy the whole time they're there, whatever. But again, use that metric. If you're much below 14% and for sure below 12% of payroll as a percentage of gross revenues, you could do with hiring a couple more warm bodies for your sales floor. So again, that's some of my focus on that perspective. The other one too, you know, in this time of year, accessory sales are big and super important. Make sure that you're not just leaning on firearm sales, even though you're in an upswinging market in total sales volume, making sure that a good chunk of that improvement in sales volume is in accessories, because that's where the profit sits, and that's how you make it a profitable business as opposed to a break even or charitable business moving forward. But again, you know, do the metrics, measure your gun inventory. How much am I pushing through my store? Figure out how many turns you're doing on it. If you have a hard time, feel free to reach out to me. I can help you work through the numbers. But that really, in my opinion, is the minimum number of times you should be doing your audits on your firearms inventory. That's all I got.
All right, thanks, Hank. All right, Matt, Josh, who wants to go first?
All right, Matt, do you want to go first?
I was going to say, yeah, go ahead, Josh.
Well, I was going to say, I have the part that puts people to sleep, so you'll have to follow that. Just bear that in mind.
Make my life easy then.
Okay, perfect. So I want to go over a couple things with you folks today in the employment arena. As you all know, the state minimum wage here in California is $15.50 as of the beginning of the year. But I want to go over some local jurisdictions whose have their own minimum wages that are above the state's minimum wage. And you guys need to be aware that those jurisdictions, many jurisdictions, that wage is going to go up as of July 1st. So right now, state minimum wage is $15.50. That's more than double the federal minimum wage of $7.25. You have to be paying a minimum of $15.50 per hour, regardless of the area they work in. There's a couple of exceptions that actually have a higher minimum wage, like computer professionals. But for most folks in retail, you're looking at $15.50. As of January 1st, if you have a business in the city of San Diego, they have their own minimum wage, and that minimum wage is $16.30. As of July 1st, here are some of the more well-known California cities with their own minimum wage, where that minimum wage is going to be going up. In the city of Los Angeles, their minimum wage on July 1st is going to go up to $16.78 per hour. The city of San Francisco is going to go up to $18.07 per hour. The city of Santa Monica is going to go up to $16.90 per hour. So is the city of Malibu. They're also going up to $16.90 per hour. City of Pasadena's minimum wage is going up to $16.93 per hour. And the city of West Hollywood is going up to a whopping $19.08 an hour. These are all based on various indices that these cities use that are supposed to be tied to the consumer price index increases or tied to inflationary increases. They all magically are different and calculated a different way, which is why you see these different numbers for these cities that have decided to adopt their own minimum wage higher than the states. And just so you guys know, on the horizon, there has been some discussion within the state legislature of further increasing the state's minimum wage. As you know, we just went through a bunch of minimum wage increases where it effectively went from about $11 all the way up now to $15.50 over the past several years. The discussion is an increase to potentially $18 an hour. So just keep that in mind as you guys are planning for staffing and other issues. You're probably going to see an increase in minimum wage if you're paying at or close to that. The other issue I wanted to talk about today is there is a case in the California Supreme Court that's going to oral argument this week that's going to affect you guys. And I wanted to talk a little bit about the case. It's called Adolph v. Uber. And it's a case that really involves two issues that intersect and affect you guys, which are what are called private attorney general action representative claims, or PAGA representative claims, and the enforceability of arbitration agreements. So you guys may recall, and we're going to get in a little bit of the sausage making here so you understand why we are where we're at and how this is going to affect you guys going forward. So the state passed a law back a couple years ago called AB 51, which was designed to stop employers from using arbitration agreements with their employees. And there has been this back and forth between the California state legislature and the California courts versus the federal courts, specifically the US Supreme Court, about whether or not you could require employees as a condition of employment or as a condition of getting a raise or continued employment to sign an arbitration agreement, agreeing to arbitrate claims. And this has been a back and forth that has been going on for at least 15 years, probably longer than that, where the state will say, well, no, you can not put certain types of claims into arbitration clauses. And then usually the Supreme Court comes back and says, no, Congress has preempted the state here with regard to the enforceability of arbitration agreements. If it's a valid arbitration agreement, yes, you can make the employee arbitrate that particular claim. So one of the claims that employers have been trying to get arbitrated, and the state has struck down or has tried to pass laws to prevent, are these PAGA claims. And what these are essentially class actions without having to certify a class. And so an employee, represented by a lawyer, of course, can bring a claim against their employer and assert the claim not only on behalf of themselves, but on behalf of all the similar employees that are affected by whatever the employee is claiming is illegal. And where sometimes they involve wage and hour issues, but where they've really come into play is with sort of non-wage claims, with these claims that are difficult to put a damages number on, that weren't really enforced up until about 10, 15 years ago. And the classic example is cashiers who have to stand the entire day. Several of them have brought successful PAGA claims against their employers, saying that, look, it's not it's not reasonable. I have to stand all day. Me and the rest of the cashiers in this store or in this chain of stores should be, we should have a seat. We should be able to sit in when we're not ringing people up. And that's the type of claim that PAGA claims adjudicate. And some of the money goes to the state, some of the money goes to the employee. They're considered a representative claim in that the employee steps into the role of the state attorney general for purposes of enforcing the law as to whatever this purported unfair employment practice is. Another example of a type of PAGA claim is you sometimes see parking attendants standing outside for a parking lot that's outdoors, and those parking attendants have to stand in the sun, and so they bring a PAGA claim on the basis that it's damaging to their health and it's too strenuous to stand there out in the sun without some kind of shade or protection. And again, PAGA was this vehicle that the legislature came up with to address claims like that, because what's the value to an individual employee of having an umbrella or some kind of head covering? That's a little more difficult and a little less likely for an individual employee to want to litigate, because there's no set value like there is with things like wage and hour violations, which are very easy to calculate. So we've seen an explosion of these PAGA claims. They have a favorable attorney's fee provision, just like with wage and hour claims and just like with sexual harassment claims. So they've become very enticing to plaintiffs' attorneys, bringing claims on behalf of employees. And we've seen an explosion of them. And as a result, employers have been trying to put PAGA claims into their arbitration clauses, and in one of two ways, or in both of these ways, actually. First, they'll say, look, if you want to bring a PAGA claim, you have to arbitrate it. And secondly, you're going to waive any class or representative claims. You agree not to be a representative or a class leader in any employment claim you bring against me. And these sorts of clauses have been the subject back and forth of all these various lawsuits and litigation. Well, so this all kind of came to a head about 1.5 years ago in a U.S. Supreme Court case that was called Viking River Cruises v. Moriana. And that's where the U.S. Supreme Court said, no, California, you can't stop. You can't stop employers from putting PAGA claims in arbitration agreements, but two, you can't require employers to arbitrate class PAGA claims if the arbitration agreement does not specifically allow for it. And in the Viking River Cruises case, what happened was there was a arbitration clause, and it said, look, if you're going to bring a PAGA claim, you can only bring it on behalf of yourself. You're going to waive class claims, and you have to arbitrate it. And the employee in that case, asked the court. They said, well, this isn't fair. I should have, as a matter of public policy, the right to bring my PAGA claim individually at the same time as my representative claim. And since it's a representative claim, you can't make that be arbitrated for a number of reasons. One, the state is not a signatory to my arbitration agreement. Neither are any of the other people whom I'm going to be representing. And so therefore, what you need to do is take the PAGA claim out of arbitration, litigate both of them together in a court, which is where me and my attorney want to be for a number of reasons. And the Supreme Court said, no, the Federal Arbitration Act has supremacy over California law. And you can't, if it's a valid arbitration agreement, you cannot make the employer either arbitrate class PAGA claims or alternatively kick the individual PAGA claim out of arbitration and put it into a court so it can be litigated alongside a class arbitration claim. A class PAGA claim. So that's where we're at with this Adolph v. Uber case. The question here is, when a arbitration agreement says, just like it did in Viking River Cruises, you have to arbitrate individual PAGA claims and you waive class claims, does that give the individual standing to still litigate a PAGA representative claim separate and apart from the individual claim they're being forced into arbitration with. Viking River Cruises didn't really answer that question because it's a matter of state law, and it's that aspect of it is not controlled by the Federal Arbitration Act. So this Adolph v. Uber case is a case that's going in front of the California Supreme Court to decide that question. So this is where that was the making of the sausage. This is where it affects you guys. If you have arbitration clauses in your handbooks or your employment agreements or wherever they are, they likely contain a PAGA waiver. They also likely contain a class action waiver and require employees to arbitrate their employment claims. So the question for you is, with language like that in your current arbitration agreements, depending on what happens with this Adolph v. Uber case in front of the California Supreme Court, those clauses may no longer be valid because the court could decide one of two things. The court could decide that, well, once a PAGA claim that's brought by an employee is forced into arbitration, that employee no longer has standing to bring a representative claim outside the arbitration, and therefore that employee can never be a PAGA representative in a separate action. That's one way the Supreme Court could decide. The other way the California Supreme Court could decide, and this is the way I think they will decide, is they will say, look, as a matter of public policy, yes, you under federal law, if you agreed to arbitrate your PAGA claim, you're going to arbitrate your individual PAGA claim, but we're still going to find that you have standing to be a representative for the same injury on behalf of your other employees in a separate action in court. And if the California Supreme Court decides that, if they say, yes, you will still be allowed to be a PAGA representative, even though you're required under federal supremacy doctrine to arbitrate your individual claim. If they decide that, you guys are going to have to change all your arbitration agreements. So this is a very important case. As we have seen in California over the past, I'd say 7 or 8 years, there have been some sea changes when it comes to the limitations that the legislature and the courts are putting on employers. I suspect the California Supreme Court is going to put this limitation on you guys. And you know, one of the frustrating things I'm sure for you and certainly for me, and what some of my other employment clients have voiced, is this constant ping pong of trying to figure out what employers can or can't do when it comes to arbitration. The volley is coming back. And so when we get a decision from the California Supreme Court on this, I'll be certain to give you guys an update. But you know, this is going to be an important one. And again, you're going to want to change your arbitration clauses if the California Supreme Court says that these representative PAGA actions can still go forward in court, because you don't want to have an arbitration agreement that has a void clause in it, because that could be the basis for a court if you ever are trying to compel an employee to arbitration on PAGA or some other claim. That clause, which would be void based on the California Supreme Court's decision, could be the impetus for a superior court judge to go, well, your entire arbitration clause is not valid because you have this now expressly void as against public policy provision in here regarding waiving PAGA representative actions, when the California Supreme Court recently said you can't make employees do that. So just bear that in mind, and we'll keep you updated. But that's all I have. You know, I think we're about to lose the rain here in California, but we'll see. I may be complaining about it when we get back together in June. And I'll turn it over to Matt.
Let me weigh in here for a second. Josh, would it make sense for folks to have, I mean, and this would be a form for every employment lawyer client we have, to have some kind of a severability clause in their arbitration agreement? Yes,
yeah, and almost all arbitration agreements these days have a severability clause, again, because of this ping pong that's been being played here for 7 or 8 years with arbitration, actually longer than that, with California arbitration agreements. So yeah, you always want a severability clause. And what a severability clause is it's a clause that says, look, if there's some part of this agreement that's held not to be valid under law, court, we still want you to honor the rest of the agreement to the extent you can. That's pretty typical in these. Nonetheless, I have seen instances where even arbitration agreements with severability clauses, as the law has continued to change, courts have thrown out the entire arbitration agreement, even with the severability clause, because there was some void doctrine in there, or some void clause in there with regard to a doctrine that had recently been adopted either by the legislature or the courts. And the arbitration agreement hadn't been updated, but the severability clause did not save it. But yeah, you should always have severability clauses in your arbitration agreements, and that's something that's fairly typical. So if you don't have one, they're pretty easy to put in.
Okay, Matt, if you don't mind, let me jump in here because I have a delivery coming any minute now. I may have to get up and sign for that. So a bit of a litigation update. As a result of the Bruin decision, cities are having to issue CCWs. Cities are doing all kinds, hostile cities are doing all kinds of things to try and slow down or stop that process, including charging exorbitant fees, requiring too many prerequisites before you qualify for a CCW, trying to limit where a CCW is valid. CRPA has something called the CRPA CCW Reckoning Project going on, monitoring all the cities that are revising their policies to issue CCWs and holding their feet to the fire to make sure they don't do anything that's contrary to Bruin. I have a call actually after this call with some of the other players to figure out whether many of the cities have been capitulating. They've been giving in as we insist that they give in, which is a good thing. But some are really trying to drag their feet, and we've got sort of our target list of the most reluctant, most resistant cities, and we're probably going to file a lawsuit against one or more of them as they finally stonewall us to the point where we're not going to tolerate it anymore. So that's number one. Litigation that we have active right now, still the big ones are Duncan and Rhodey, and then there's also the Miller case in front of Judge Benitez. There's also a Billy Club case down there in front of him on the Second Amendment. We're waiting, I expect he's just being very careful. He caught a lot of crap from the last one because he said AR-15s were like Swiss Army knives, and they jumped on that analogy, even though it's accurate. They misconstrued it, mischaracterized it to make it sound like he's diminishing the way that AR-15s have been and semi-autos have been used in tragic mass shootings. So I think he's just being careful, but we could see an opinion on those 4 cases from him any day. There are assault weapon laws being passed all across the country in the battleground states, the hostile states. And we're monitoring all of those. We were involved in the Illinois case and helped get an injunction out of that court just the other day. Then we have the Boland case, which is one of 2 challenging the roster. We got a great ruling from our judge in that case, and kudos to Josh and Matt for their work on that lawsuit, striking down the loaded chamber indicator, magazine disconnect, and microstamping requirements. Interestingly, the state does not seem to be appealing the microstamping requirement, but I think that there is a bill pending in Sacramento that would change the way microstamping would be required so that the manufacturers would have to send if they don't want to put microstamping in themselves, they'd have to send it to a gunsmith or some kind of a technician to put microstamping on the gun before it could be sold in California. Whatever comes there will be more litigation. The Boland case is on appeal. We're preparing our brief and also working on some amicus briefs. I expect that FFLGuard will be named as an amici on one of those briefs, pointing out the issues for retailers. We have Glendale sensitive places, which we're probably going to get a decision, a stipulation from the city that says certain places are sensitive and others will not be decided because SB2 is pending, which would designate a lot of places as sensitive. We have our Junior Sports Magazine v. Bonta, which is the case that challenges the ban on marketing to minors. We have Rupp v. Vicera, which challenges the California assault weapon law, which is behind Miller, so Miller will probably be decided on that first. We're still monitoring San Jose, their insurance requirement. Looks like the state may try and, actually, I think the mandatory state insurance requirement was made a 2-year bill in Sacramento. And I just offered to Chris and Brian that if they want to have Rick Travis or Sam Paredes come on next time and talk about all the things that are going on in the Capitol. There were about 100 bills introduced, gun control bills. About a third of those have been sidelined for now, but they're still fighting the rest. And there are also a lot of spot bills, basically placeholder bills that could be amended to become gun control bills. Basically, this is Newsom's temper tantrum over the Bruin decision, where he's just trying to pass anything that will make it harder to own a gun. We're also litigating a couple of gun show cases. One of those was just argued because they're trying to ban gun shows. And we have the challenge, the damages lawsuit brought by a deputy district attorney over the DOJ's CCW information breach. So we got a full plate, whatever you can do to help. And CRPA is funding most of it. Whatever you can do to help get us more members and more donations to CRPA, it goes straight to those lawsuits. And we charge, just as we charge FFLGuard clients significantly reduced rates, we do the same for CRPA. So, we're activists, not just advocates. One thing I would ask, Hank, you were talking about business being up for dealers in California recently. Is there anything in particular that you can attribute that to?
Yeah, I tried to look through a lot of the laws and, things that are coming and acting that might be spurring business. I don't know if this is any coattail stuff from the Washington State stuff. I can't really put a finger on it from that specific perspective. I did a fair amount of online research to see what might be spurring it, because typically when we see spikes to that level, double-digit increases, it's usually political in nature. And I have not been able to find it, so I just rack it up to the climate is just positive and the dealers are doing a good job. That's about, again, I tried to find a reason underneath it all, and I just have come up with nothing. If anyone on the call has any suggestions as to what they're seeing, I would love to hear from them.
What specifically are you seeing as far as increases in sales?
Yeah, so I can't see it at a item by item level, but I'm seeing it at the total sales level, and also at sort of the excuse me, the average transactional value level. And they suggest that it's leaning into firearm sales more than accessory sales, which is always for me a cautionary bell that people are buying guns but not the stuff, which diminishes the profitability of the overall transaction. But average sale value is up. And also, again, if we look at same period versus same period, total sales volume is up by about 30%. So there's something spurring sales in California that's very anomalous. That's not even approaching Washington increases. Washington's up a little bit just because of the laws and such. But yeah, no, California is bucking the national trend by a large factor.
Okay, guys, so I've got to jump off this call, but the good news is it looks like roster will go away, at least to some degree. So that will open up a lot of sales for you guys. We're reaching out to the manufacturers to try and get help with that.
Chuck,
One second, guys, 1 sec, I know. I got another call, multitasking, Monday morning. Then you've got semi-autos, which I think will be unbanned, and more people buying carry guns. So I think it's a very hopeful time on top of the political environment, which is driving people to buy. Okay, so I got to jump off. I appreciate everybody listening in, and we'll see you next time.
Thanks, Chuck.
All right, so kind of just dovetailing off of what Chuck was talking about. As far as a regulatory standpoint, regulatory update, the California Department of Justice has been largely quiet for a while now. The most recent, I should say, action that they've took on a regulatory level that potentially impacts firearm dealers and manufacturers is that they created a sort of invitation for firearm stakeholders to propose preliminary comments on what at the time they were doing were proposed rulemaking regarding microstamping. Of course, that was out in December of last year. And since then, as Chuck mentioned, we had the decision in Bolin. And as a result of that, I don't think that that is going to be going anywhere with the California Department of Justice, especially given that they are not pursuing the appeal on microstamping. But nevertheless, there is, of course, as Chuck mentioned, there is a pending bill that, again, I think the pending bill was originally written and introduced before the Bolin decision came out. So it remains to be seen what the legislature will do with that, but just nevertheless know that it is out there. In California, touching on what Michael was talking about regarding gun trusts earlier, things NFA trusts specifically, I should say. Of course, in California, from what I've seen, generally speaking, NFA type trusts are typically a no-go in the state of California, largely not because they're prohibited in the state, but because of the way the firearm transfer requirements take place here in California, specifically the DROS requirements as a general rule require, for example, the transferee presenting a valid California driver's license or California ID. And in which case, in the case of a trust obviously itself won't be able to present that. And so from a practical standpoint, it's there's no way in California as it stands to legally transfer a firearm to an entity like a trust, with the very limited exception, of course, to a California licensed firearms dealer for purposes of acquisition in their bound books, that kind of thing. So for the most part, if you have questions from your clients, things like that, as far as what they can do to potentially transfer the gun to a trust, just be aware that while there's no specific restriction in California against that, it's the practical ways that we have as far as how transfers take place that sort of act as a bar on creating what you can do in some other states as far as NFA trusts are concerned, things like that. But not just limited to NFA items either. Just if you, for example, you have a customer that comes in and wants to create a trust for their family in the event of their passing or something like that, or just as a general way of maintaining firearms within the family, it's still the same issue still applies. Of course, the ATF, their regulations concerning pistol braces, my understanding is individuals currently in possession of those have no later than May 31st to take specific actions, whether it be registering them with the ATF or otherwise. But of course, again, California being California has its own rules and restrictions on what it considers short-barreled rifles, things like that, that would potentially mean that if these items have now been reclassified as short-barreled rifles within the guise of the ATF, it's not something that you'll be able to lawfully register with the NFA division of the ATF and still maintain possession in California because of California's own specific rules requirements regarding short-barreled rifles that generally don't allow individuals other than law enforcement to be in possession of such items. Chuck, of course, did also mention some of the pending bills, SB2, the CCW bill. The one that I'll call attention to for firearm dealers, specifically Senate Bill 241. This is a mandatory training requirement that the California Department of Justice would basically create a it's difficult to say obviously exactly what they would do with this, but for example, think of it like a FSC requirement for dealers and their employees, where they basically have to undergo certain basic minimum training on a regular basis to be able to engage in the business of selling or transferring firearms. And so that bill is something that it is pending still, of course, obviously, so we don't know exactly where it's going, but we're keeping an eye on it. And as soon as we know if, for example, it's going to go to the governor's desk, and obviously the governor would more likely than not sign something like that, we'll let you know, and we'll, of course, update you with what the specific language is in the bill once it's in its sort of final version as it goes to the governor's office, and we can start helping you guys prepare for whatever potential training requirements, things like that, would be coming out. Beyond that, that's, like I said, it's been the California Department of Justice has been largely quiet from a regulatory standpoint. I have seen, and this is just anecdotal, of course, but I have seen a large uptick in ATF enforcement actions against dealers in California, specifically follow-ups on inspections, things like that. And we've seen quite a number of revocation hearings taking place in California. So the ATF is still around in California. They seem to be picking up a lot from where they were previously in the state, from what I've seen. So obviously, you guys want to make sure that you're implementing any sort of training standards, protocols, things like that, to, of course, make sure that your record keeping is up to snuff and won't cause any issues with the ATF. And so, of course, the team at the FFLGuard offices can help you guys with that if you guys have any questions or concerns about that. So that's it for me, unless there are any other specific questions. So I'll hand it back over to you, Avis.
Matt, there's a question in the chat room about a statement that Chuck made that the rosters will go away to some degree.
Yeah, I think Chuck was being a little bit more short in that response. So let me make clear, at least from my understanding, the roster is not going away as a result of Boland, at least anytime soon. There will still be a roster. It's just that the microstamping requirement is currently not enforceable. And so if a manufacturer wanted to submit a gun for testing, it doesn't have to comply with the microstamping requirement. It still has to comply with the drop test safety requirement, the fire safety requirement, as well as the chamber load indicator and magazine disconnect requirement, pending a final decision on the merits, of course. And so whatever that final decision is will ultimately determine what happens here. But again, the roster is still in place. Let's just to make that clear. And I don't see that roster going away anytime soon, at least until we get a final decision that says otherwise. But nevertheless, it is something that is a little easier for manufacturers now to comply with, and which is what I think Chuck was getting at there. So just to sort of give a little bit more detail on that, if that answers the question.
Yeah, and I'll add to that. I don't anticipate that whatever final decision we get out of the trial court in Boland will strike the entire roster, based on the comments that the trial judge made when he granted our preliminary injunction to strike microstamping, magazine disconnect mechanisms, and chamber load indicators. He indicated that he was likely going to leave the drop test requirements in place. Now, as Matt said, the state appealed the injunction, but only as to magazine disconnect mechanism and chamber load indicator. So as of right now, until the Ninth Circuit rules one way or the other on it, the Ninth Circuit has temporarily said the chamber load indicator, the magazine disconnect mechanism requirements are still enforceable, but the microstamping requirements are not. So we do understand there are manufacturers that are submitting for testing. We don't know what the DOJ is going to do in response to that, given that everything is up in the air. Our argument is going to be, and we're planning to potentially file litigation or augment our filings in Boland to address if the DOJ doesn't process new roster submissions in light of what's going on. If they take the position that somehow they don't have to do anything, we will probably force that via further legal action. But as of right now, you're going to be subject to a roster. I think when Boland's over, if everything goes as we hope, you're going to be subject to a roster, but the only requirement is going to be the drop testing. But we'll see what happens.
Okay. Thanks for the help. And thank you for all the information, Matt, Josh, everyone that's been on the call today. We will have our next call on June the 5th. So you will receive some emails about that, and I'll publish this later in the week. And have a great first week in May. Thanks, guys.